Everything is right.
And before I delve into the topic that was designated to me, I would just like to again thank Alyosha for organizing this very important educational events and for all the efforts of him and his team invested in raising awareness about these very important topics, not just domestically, but also internationally. So thank you, Alyosha, very much for that. So I was asked to speak about the little bit about the practice of the UN Human Rights Committee when it comes to issues of climate change. But before doing that, I would just like to add something to Stephen's response to the last question about the carbon dioxide removal techniques, just to point you to the report of the UN Human Rights Council's Advisory Committee, in which I am now serving, which was published. It was published last year, and it is titled "Impact of New Technologies for Climate Protection on the Enjoyment of Human Rights," in which the advisory committee actually opined that at the current stage of development, all these new technologies intended for climate protection are not climate neutral, and actually suggested a moratorium unless it is proven that it would actually have more positive impacts on the environment than negative ones. So just to point you to this report for anyone who is interested in reading it. Now turning to the different animal, which are the treaty bodies that are established on the basis of various human rights treaties adopted within the United Nations. I think it's important to note that members of these committees act as independent experts, so they are not representing their governments, but actually act as independent experts and are usually elected for 4 years. This is also the case for the Human Rights Committee. And the mandate of these committees, including the Human Rights Committee, is to monitor implementation of the core human rights treaties, which they do through periodic reviews of the state parties, which is a procedure that evolves over several years. And finally, the constructive dialogue takes place in Geneva at the headquarters of the Office of the High Commissioner for Human Rights. Then there is a possibility for individuals to submit complaints to these bodies. Not all, but Human Rights Committee is one of those, subject to acceptance of such jurisdiction of the committee, which in the case of the Human Rights Committee means that the state had to ratify not only the International Covenant on Civil and Political Rights, but also its first optional protocol. If the committee then proceeds with meritum decision on the case, it adopts the views, and these views, although not binding as a judgment of a national or, let's say, regional or international court, has a significant weight, given that all the states are expected bona fide to comply with the recommendations issued in these views, as they have accepted this by ratifying the optional protocol. Then the committees also adopt general comments, or they're called recommendations in case of two committees, in which they provide authoritative interpretation of the obligations arising out of these core treaties. And many states ascribe great weight to these general comments. Some in domestic legislation even recognize some legal weight to these general comments. Perhaps important to note is that also the International Court of Justice in its jurisprudence, particularly in the Ahmadou Sado Diallo case, also recognized the importance of these general comments for interpretation of the rights under the relevant treaties, which might be particularly pertinent in the context of the now ongoing advisory proceedings on climate change obligations of states. Finally, there is also a possibility of states to bring interstate communications before certain committees. Although this is rarely used in practice, there have been some examples before the Committee on Elimination of Racial Discrimination, but none yet before the Human Rights Committee. Now, turning to the issue of climate change and the work of human rights treaty bodies, I would like to note that several have already engaged in these topics at various stages, both when reviewing states parties as well as when deciding on individual complaints. Also, they have been adopting general comments which have been touching on the issue of either environmental considerations, but also more explicitly climate change. Particularly, I think it's important to mention the recent general comment adopted by the Committee on the Rights of the Child last year. This is general comment number 26 on children's rights and the environment, with a special focus on climate change. Since I will not be going more into detail of the work of the Committee on the Rights of the Child, I just wish to also note that the committee had the opportunity to decide on the individual complaint that was brought to it by Saki and others versus Argentina, and that in that case, the court found the complaint inadmissible due to the non-exhaustion of domestic remedies. And I think that was quite an important precursor to what then followed also in the more recent decisions before the European Court of Human Rights, where this argument was also used by the court in the cases presented to it. For those who are interested to perhaps have a more comprehensive overview of what the committees have been doing on these issues, there have been various studies presented. I just refer on one of those here on this slide. Now, going more to the work of the Human Rights Committee. First, as I said, the committee has engaged in the issue with the issue of climate change, both in its periodic reviews of states parties as well as deciding on individual complaints. But it has also adopted one important general comment 36 on the right to life, to which I will refer in a moment. Before doing so, I wish to stress that before encountering, let's say, complaints claiming human rights violations due to adverse impacts of climate change, the Human Rights Committee had the opportunity to engage also in complaints alleging violations of human rights due to adverse impacts of environmental degradation. And in that sense, because I will have no time to go more in depth to these cases, I would just like you to refer you to two cases. One is Portillo Cáceres versus Paraguay, and the second Benito Oliveira and others versus Paraguay, which set an important scene, let's say, for the later decisions on the more climate-oriented cases. Now, the general comment that I mentioned, general comment 36, is important for the topic, especially because of its paragraph 62. Namely, in paragraph 62, the Human Rights Committee pointed out that climate change, in addition to environmental degradation and unsustainable environment, is one of the most pressing and serious threats to the ability of present and future generations, and here we have this element of future generations as well, to enjoy the right to life. And it explained that this includes also life with dignity. So not just physical existence, but the existence of a certain quality, if you will. And adverse impacts of climate change, of course, have significant effects on the quality of life of people in many parts of the world already, and this will continue to happen as we go ahead. And finally, at the end of this paragraph, also specifically called on states to pay due regard to the precautionary approach. And again, I think this is an important indication of what should be the elements taken into account when interpreting human rights in a, if you will, harmonious manner, if we are talking also about the European Court of Human Rights interpretative methods. Now, the engagement with climate change implications for human rights basically started with periodic reviews based on this general comment number 36. And by now, the committee has adopted many concluding observations for states that were under review, including specific recommendations referring to climate change. I'm here just for the purposes of presenting two examples, mentioning the periodic report of Kenya, the concluding observations on this report, and also for Germany, where the Human Rights Committee specifically referenced also the Federal Constitutional Court's decision as a very, let's say, important, far-reaching decision, although there are different views among even German lawyers as to what the court did in this particular case. Going now to a more perhaps directly relevant decisions of the Human Rights Committee for Climate Change Concerns, I would like to refer to the two examples, Jane Tetoita versus New Zealand views and the views in the based on the complaint brought by Billy and others versus Australia. I'm very cognizant of the time, that's why I'm going a little bit fast, so I hope there will be some time for questions as well. The case of Mr. Tetoita is considered as the first human rights treaty body decision directly addressing the human rights implications of climate change. And what is noticeable in this case is that Mr. Tetoita, who was represented by a counsel, decided to argue only violations of his rights under Article 6. So that means right to life. And whether this was fortunate or unfortunate, it's hard to say, but having been a member of the committee at the time of the decision-making on this case, I can reveal that there were some discussions on what could have been, you know, let's say, assessment of various evidence and arguments had there been other articles argued in the case. The facts of this case is that Mr. Tetoita, together with his wife, moved from the Kiribati, which are significantly impacted by adverse climate change implications, to New Zealand. While living in New Zealand, they had 3 children, so the 3 children never had any contact with the living conditions in the Kiribati. And when they were discovered of staying illegally in New Zealand because they didn't resolve their status in New Zealand, they applied for asylum. When their application was denied, they were eventually removed to the Kiribati. So they have exhausted all available domestic remedies in New Zealand. And now when they complained to the Human Rights Committee, Mr. Tetoita actually wanted to bring the complaint on behalf of himself, his wife, and the children. The problem was that it was only Mr. Tetoita who signed the power of attorney for the council to represent him before the committee, which is why the Secretariat of the Human Rights Committee decided to register the case for Mr. Tetoita alone. I personally have certain, let's say, troubles with this decision for reasons that when a parent is bringing a claim on behalf of the underage children, that should, without their signature, be recognized as a complaint brought on behalf of the dependents as well. But that was the fact of this case. So in this case, where the Mr. Tetoita, through his counsel, was arguing that the island of Tarawa, which is one of the islands in the Kiribati, have become uninhabitable due to contamination of drinking water due to the sea level rise, then land disputes because of, obviously, lack of arable land due to, again, sea level rise, and many other reasons. He said that returning him to the Kiribati actually violates his right to life, as he will have no possibility to have a life with dignity in the Kiribati. In order to decide these so-called expulsion cases or refoulement cases, the Human Rights Committee established certain standards to look at. And the Human Rights Committee always looks at whether there are substantial grounds for believing that there is a real risk of irreparable harm. And this risk must be personal and cannot derive only from general conditions in the receiving state, except in the most extreme cases. So it's a high threshold for providing these substantial grounds to establish this real risk of irreparable harm. In this assessment, all facts and circumstances are considered, including the general human rights situation in the country of origin of the complainant. But now the crucial part is the test. The test is that essentially it is for the organs of the states parties to the ICCPR to examine the facts and evidence of the case in order to determine whether such risk exists, unless it can be established that the assessment was, and now the three possible reasons, either clearly arbitrary or manifestly erroneous or constituted a denial of justice. And I'm emphasizing this because the Human Rights Committee cannot decide the case de novo, so to say. It is more or less limited to written proceedings, although theoretically it could have a possibility to organize oral hearings, but that is very rare to happen. And based on the fact that it has only, as I say, submission complaint by the author, as well as responses, observations by the government, it has very limited possibility to engage with this evidence and information as presented. And therefore, this very stringent test, it has to be clearly arbitrary, manifestly erroneous. Just an error is not sufficient, or it has to constitute a denial of justice. Now, based on these standards, the Human Rights Committee in this case determined that New Zealand had not violated his rights by deporting him back to the Kiribati. Nevertheless, the New Zealand authorities, already in domestic proceedings, and then the Human Rights Committee also following these arguments in its decision, recognized that the climate change adverse impacts on the living conditions of someone can trigger the non-refoulement obligations of the sending states. So this, in a way, responds to the discussion whether, people displaced due to climate change effects enjoy the same right of non-refoulement as refugees, for example, under the Refugee Convention. Both the New Zealand domestic authorities as well as the Human Rights Committee very explicitly expressed the view that actually the non-refoulement does protect these people in general, in principle, displaced due to climate change. And another very important point in paragraph 911 of the views in this case is that the committee said that not only states, domestic authorities, are responsible for taking the necessary measures to mitigate and adapt to climate change, but that there is a need for international efforts as well. So if you look at the beginning of this paragraph, the committee said that without robust national and international efforts, the effects of climate change may expose individuals to a violation of their rights. By including this explicit language, it was somehow sending a message to the states parties to the covenant that perhaps in the future, if they will not engage in these international efforts, they might share responsibility for the individuals who will be displaced due to climate change effects. And if they will not invest in terms of not just financial means, but otherwise as well, they might violate their obligations under the covenant. And why? Because the situation of having an entire country submerged underwater due to climate change is such an extreme risk that the conditions of life in such a country may become incompatible with the right to life with dignity before the risk is realized. again, I think a very important pronouncement, because here the committee said we don't need to wait for these individuals to already become a victim in a classical sense of the term, but we can consider them as victims when this threat is so present and imminent that the obligations of states are actually triggered before this risk is realized. Now, in this case, I also penned my separate dissenting opinion, because I felt that the treatment of the domestic authorities in New Zealand, of the argument of the applicant, of the complainant, that they will have no access to safe drinking water, which will seriously jeopardize their life with dignity, has not been given due consideration. In fact, that the treatment of domestic authorities of this argument was arbitrary, or clearly arbitrary, or manifestly erroneous, and that for these reasons the committee should have found a violation of Article 6 that New Zealand decided to return Mr. Te Toita back to the Kiribati without seriously considering this argument. And what was interesting in these discussions in the committee is that many of my colleagues on the committee were not really sensitized, I would say, about this important difference between the potable water, which is what was the government's language and even the language used by the Human Rights Committee, and the right of access to safe drinking water, because even potable water can lead to the living conditions which could not be considered as dignified under Article 6. Now, moving quickly on to the second case, which is perhaps even more important, the so-called Torres Strait Islanders case, Billy and others versus Australia, which was decided in 2022. Torres Strait Islanders is again considered the first human rights treaty body decision finding violations for human rights impacts of climate change. The petitioners are members of indigenous peoples, Torres Strait Islanders, adults and their children. The claim was brought on behalf of adults and the children against Australia, so highly industrialized state with significant contribution of greenhouse gas emissions with limited, let's say, measures of mitigation. There were a number of interventions in this case, and this is also an important detail, because it's not very often that the proceedings before the Human Rights Committee will see third-party interventions, but this is one such case, and also the Special Advisor for the Right to Clean, Healthy Environment intervened, as well as some others. It is a case of, I would say, strategic litigation, and for this reason, I would guess there were also a series of human rights violations argued, which is always better, I would say, because then you have better chances to succeed with at least some of them. And again, in the interest of time, I will just focus on the finding of this case. Basically, what is happening is, again, the sea level rise and the effects on the length of the Torres Strait Islands, which impacts the life of these indigenous peoples. Now, in this case, an interesting, again, fact was that the state party, Australia, argued that there are no domestic remedies available that petitioners could use to argue their case. Australia is one of the few countries that doesn't have the list, the catalog of human rights in its constitution or any other relevant legislation. And it was the argument of the state party that there exist no available domestic remedies for this particular case. And I'm emphasizing this because this was the reason why the Human Rights Committee, in fact, did not engage with the issue of exhaustion of domestic remedies. When the state party argues itself that there are no such remedies available, the Human Rights Committee will not go proprio moto contradicting the position of the state party. And for this reason, the committee found no issues with admissibility of the case, admitted the case, and then decided it on the merits, contrary to what was the case before the European Court of Human Rights, where the non-exhaustion of domestic remedies was one of the main arguments of the states in Duarte Agostinho versus a number of states to the convention. So the committee found a violation of two articles. Article 17, right to family life, private family life, and Article 27, given that indigenous peoples also enjoy rights of their cultural life. Article 27 refers to the rights of minorities of the ICCPR. So this is a particular issue, let's say, because we are dealing with an indigenous people. However, the committee did not find a violation of Article 6, right to life. On a very tight, let's say, vote, 5 separate opinions were appended on this issue. Not everyone who voted against appended a separate opinion, so it was a really tight vote that Article 6 was not found to be violated in this case. I was still there at that time. And to my regret, the committee also decided not to decide, it was the decision not to decide on the claims under Article 24 of the Covenant concerning rights of children of these indigenous peoples. I'm regretting this because I feel that although right to family life under Article 17 does concern also children, but there are particular also rights of children that could have been assessed based on the claims brought by the individuals. Now, what we see here is very similar with what happened in Klimaverein Seniorinnen, now before the European Court of Human Rights. The European Court also decided to find a violation of Article 8, which is similar to, let's say, Article 17 in certain respect. But contrary to what the committee did, and that is perhaps a little progress, decided not to decide on Article 2. So in this case, the Human Rights Committee found no violation of Article 6, but in the European Court of Human Rights case, the court decided not to decide on Article 2, which perhaps is a little progress in that respect. So the separate opinions, partially dissenting opinions, I will focus only on those, and especially the one that I joined, together with my colleagues Marcia Kran and Arif Bulkan. We explained that what we think happened in this assessment in the committee is that the wrong standard was used, basically. That the committee was too focused on the standard that it uses in the so-called non-refoulement or expulsion deportation cases that I explained earlier. So a real and foreseeable risk, whereas we felt that the standard that should have been used was more a reasonably foreseeable threat. And that based on this factor, if it would have been applied, that the committee would have had to recognize that there are certain effects on the life of these individuals, and there is a serious threat, clearly foreseeable threat for the lives of these individuals, and that this should be assessed separately from the risk to their right to enjoy their culture. So we strongly felt that there was a missed opportunity for the committee to pronounce on Article 6 violation, and especially failing to consider also the precautionary approach, and that there have been, as I said, effects already existent at the time of the filing of the communication of the petitioners, and that based on this, the committee should have decided on the violation of this right as well. So I'll stop here, and I'm looking forward to the discussion. Thank you very much.